When people or companies sue each other, they go through a process called discovery where they trade information about the case. Each side asks the other side to produce information that's relevant to the case. For the past few hundred years, discovery has mostly been done using paper. It was not uncommon for companies to have warehouses filled with boxes and boxes of files. But since the dawn of the computer age, most data is now stored electronically. The courts have recognized this shift in information storage and have expanded the discovery process to include electronic data. Finding, collecting, and producing electronic data during litigation is known as electronic discovery, or e-discovery. There are, however, a lot of problems associated with the e-discovery process. For example, whereas paper is always just paper, electronically stored information, or ESI, can come in a myriad of different formats like word processing documents, spreadsheets, email messages, databases, sound recordings, videos, and many others. Just to give some perspective on the volume of information we're dealing with, consider this. At least 90% of corporate communication is done by email. Many email messages also have attachments. These email messages and their attachments are stored in a lot of different places: on people's computers, on company servers, on cell phones, and on backup tapes. So what happens when you get sued and have to find this information in a complex IT system? If your company isn't ready for e-discovery, this can be an extremely costly and time-consuming experience. Now let's take a closer look at the steps in the e-discovery process and see how quickly the costs can mount. The first step in the e-discovery process is identification. In this step, the company locates any sources of electronically stored information that might be relevant to the case and figures out how to collect it. Please notice the downward sloping triangle on the left labeled volume. This triangle shows how the quantity of information decreases as the e-discovery process moves forward. The second step in the process is preservation. Here, the company makes sure that its ESI is protected from being changed or deleted while the lawsuit is going on. This can be a huge challenge since employees rely on their data to work. A company can't just stop using its files until the lawsuit is over. Once the company has identified and preserved the relevant data, it's time to move on to the collection step, where the company gathers all the ESI related to the case. After the ESI has been collected, the next step is processing. In this step, the volume of ESI is reduced by removing duplicate and irrelevant information. For example, email chains that contain the same messages twice, or duplicate documents that were saved on more than one computer. The data set is searched using keywords and concepts that are relevant to the case. Files may also be converted to different formats that are more suitable for the next steps in the process. Notice the upward sloping triangle on the right labeled Relevance. This shows how the data set becomes more relevant as it moves through the process. Now we move on to the next step, Review. Here, the company's law firm reads through ESI that's been collected and processed to make sure that it's relevant and that none of it is considered private or privileged communication between the company and its lawyers. Analysis is an important step in this process. As data is being processed and reviewed, the company learns more about the data collected, tweaking its process to find only the most relevant information. Once the information has been collected, reviewed, and analyzed, it's ready for production. At this point, the company delivers the final and most relevant ESI to the opposing counsel. If the case goes to trial, or if information is used during other court proceedings, lawyers may be responsible for presentation. This is where the attorneys display the relevant evidence in a clear and concise format to support their arguments. So now that we've discussed the e-discovery process, try to imagine how it would affect the following hypothetical case. Engineering Incorporated, or EI, is a mid-sized engineering firm that recently fired one of its employees on suspicion of theft of trade secrets. The company hired an industrial security firm to investigate the theft, and they found computer logs that show the employee accessing the stolen information from a company computer, video evidence from a hidden camera pointed at the computer, RFID data from the computer room's keycard access system, GPS information from a tracking device located on the employee's company car, and text message information from the employee's company cell phone. But the suspected employee denies the company's accusations and has countersued for wrongful termination. As part of the discovery process, the company is required to locate and produce all the electronic evidence gathered by all of its systems. Unfortunately, the company has no data management processes or policies in place, and as a result, the requested information is haphazardly organized and stored. Now the company has to ask several employees in the IT department to spend time locating and collecting the required evidence. As time goes on, the cost of this process increases and productivity decreases because now these employees are not doing their normal jobs. Once all of the information has been collected and processed, the company's law firm bills the company hundreds of dollars per hour for its lawyers to review all the information before it's produced to the other side. As one could imagine, This step is the most expensive part of the EDiscovery process. Once all of the necessary information is produced and the final costs are totaled, it's clear that the company could have saved a ton of money by taking preventative steps to organize their data instead of wading through its disorganized IT system. It's also important to realize that you don't have to be sued directly to be dragged into an EDiscovery situation. Third-party companies such as the industrial security firm that provided services to catch the employee in the hypothetical situation will also be subject to the EDiscovery process. If this firm doesn't have a highly organized data management system, it will also feel the financial pain of EDiscovery. Companies should understand that EDiscovery doesn't have to be expensive and painful. Being proactive can greatly decrease the cost and complexity of an organization's lawsuits. In addition to decreasing the cost of litigation, a proactive data management strategy helps to organize and classify records, creating tremendous cost-saving opportunities. Because employees can find information faster, their productivity increases. Because the company is storing less information, its storage costs decrease. For better or worse, EDiscovery is here to stay. Companies have two choices. They can wise up to the benefits of preventative EDiscovery, or they can find out about them the hard way during litigation. A company that is proactive will save a lot of time and money. A company that keeps its head in the sand faces a real potential for financial ruin. So Daniel, you have a lot of experience with EDiscovery, and I'd like to thank you for volunteering your time to help us understand this topic. In your experience working with companies and their outside counsel, what's the most important thing companies need to know to handle EDiscovery?
A lot of companies don't understand the risks associated with EDiscovery. It's really a needle in a haystack kind of problem that we're dealing with. We get sued, we have to produce certain information related to that case, and so we have a big and potentially complex IT system that we have to look through in order to find that information. So most companies aren't really equipped to handle that in a cost-effective way, and you see a lot of companies settling lawsuits that they wouldn't otherwise be settling just because it's so expensive to litigate them. The other thing that most companies don't realize is that they can be proactive about EDiscovery and address some of these issues before they come up. There's a lot of cost savings associated with that. We're encouraging clients to organize and retain their data better, to keep less information around in the organization, and that translates to some significant cost savings on the IT side.
So what should a company do to protect itself and keep its litigation costs down?
Well, there are a couple things really that companies should be looking at. The first thing that I just mentioned is encourage clients to keep as little data as possible. If it's not a business record, if it's not subject to regulatory compliance, and if it's not subject to some kind of litigation, we really should be getting rid of those records. Another thing that companies don't typically deal with is policy related to these issues. Data management policies that talk about the way they keep data around in the organization, how they're organizing and classifying records. So we have policies written often, but they aren't properly implemented. A company says it's only going to keep email for 1 year, but that's just what it says on the policy. We don't actually have systems in place to enforce that and make sure that users are being trained on that and certifying that they understand and are complying with that policy. Another thing that companies really need to be doing is looking at EDiscovery as a cross-functional problem. It's not something that just the legal department can handle or just IT can fix on its own. Different functional groups in the organization need to be involved with solving the problem. I see a lot of companies relying on their outside counsel to deal with these issues. And unfortunately, EDiscovery is more an IT problem than it is anything else. And so we have to have that collaboration in order to see any sort of progress in trying to decrease our risk.
Well, once again, Daniel, thanks a lot for coming in, and your information has proved quite valuable.